tonight's speaker is Kevin John Heller. Kevin is currently a professor of criminal law at the School of Oriental and African Studies at the University of London. And before he joined SOAS in 2014, he was associate professor and reader at Melbourne Law School, also serving as project director for international criminal law at the Asia Pacific Center for Military Law. He holds many esteemed degrees, and his writing is prolific in all top-quality journals and publications. I'm sure you all are aware of that. And I personally have had the privilege of being colleagues with Kevin on another one of his ventures, the Opinia Juris blog, which hopefully many of you are familiar with, and if you're not, I encourage you to get familiar with it. Kevin's CV is very long and impressive, as you may be already aware, and if not, I invite you to have a look more on the SOAS website. In tonight's lecture, he's going to answer the age-old question for us: what is an international crime? I know you're all dying to know what that is, so am I. So without further ado, Kevin, you've got the floor.
Thanks. Okay. Well, thank you all very much for coming. I'd be very curious to see what you think of this talk. I've given versions of it a couple of times, and everyone really, really hates it. I think the only person who I even have a shot at actually having agreeing with me is my friend Dov Jacobs there. But I look forward to you telling me why I'm completely and utterly wrong, because as you'll see, I'll be taking on what is probably the most central tenet of international criminal law. I hope to speak only for 30, 35 minutes at the absolute utmost, leaving us plenty of time to have a good conversation afterward. So, the question: what is an international crime? First thing to be said is that there are two aspects to the question. First, we have to identify which acts actually qualify as international crimes. And second, and I think more fundamentally, it asks us to identify what is actually distinctive about an international crime, what makes something an international crime. Now, in terms of which acts qualify as international crimes, international criminal law scholars have offered a bewildering variety of answers. Obviously everybody agrees on the core international crimes. We have war crimes, crimes against humanity, genocide, aggression. Some scholars will add torture and terrorism to the list, and other scholars will add even more esoteric crimes like mercenarism or cutting underwater submarine cables. So you get a lot of different answers to the first part of that question. But following Nuremberg, or after Nuremberg, almost all international criminal law scholars will provide the same answer to the second question. They will all say that an international crime is an act that is directly criminalized by international law, what I call the direct criminalization thesis. That definition of an international crime, in turn, is then supposedly able to distinguish between international crimes and transnational crimes. A transnational crime, then, is an act that is not directly criminalized by international law itself, but is criminalized by states domestically in response to a consensually accepted international obligation. You ratify a treaty, and you have an obligation to criminalize that act domestically, and that's the definition, traditionally, of a transnational crime. Now, what I want to do in this lecture is challenge what I call the direct criminalization thesis. Or perhaps more specifically, I will argue that the direct criminalization thesis can really only be defended on the basis of at least what I consider a deeply problematic naturalist conception of international criminal law, on the creation of international law. So my argument's going to proceed in three parts. Section 1 will be the bulk of it, and it will explain why I think it's impossible to defend the direct criminalization thesis on the basis of a kind of classic positivism, and why, if we attempt to defend the direct criminalization thesis on the basis of positivism, the idea of an international crime really collapses into what I call the national criminalization thesis. It collapses an international crime into an act that all states in the world are equally obligated to criminalize domestically. And that's the idea of an international crime that I will defend. So then in Section 2, I will argue that what I call the national criminalization thesis actually has a much stronger positivist foundation than this idea that there are certain acts directly criminalized by international law. And then finally, in section 3, I will attempt to destabilize the international-transnational distinction by showing that at least some transnational crimes may very well have a stronger positivist claim to being an international crime than some of the traditional international crimes, in particular genocide, crimes against humanity, and aggression. So it's a fairly ambitious talk. I'll give you the best sense of my argument that I can. It is a fairly dense talk, and I deeply apologize for that, but hopefully you'll be able to follow it and we can talk about it. So let me start with the direct criminalization thesis. The seminal statement of the direct criminalization thesis remains the insistence in the IMT judgment, particularly this last part: crimes against international law are committed by men, not by abstract entities, and only by punishing individuals who commit such crimes can the provisions of international law be enforced. Individuals have international duties which transcend the national obligations of obedience imposed by the individual state. Now, I promise you I will not read you all of my slides. I know you're all capable of reading. I will just highlight the important part. The direct criminalization thesis is really even more clearly articulated by the International Law Commission in Article 1.2 of the 1996 Draft Code of Crimes. Crimes against the peace and security of mankind are crimes under international law and punishable as such, whether or not they are punishable under national law. So the direct criminalization thesis really embraces 3 interrelated assumptions. The first is that the international criminalization of a particular act in no way depends on whether that act is criminalized by states. Again, it doesn't matter whether states punish them, they are still criminal under international law itself. That's the first assumption. The second assumption is that an international crime is an act that is universally criminal. If the international duty to avoid committing a particular act cannot depend on its status in national law, well, that act is criminal even if every state in the world considered it to be completely legal. Again, it is criminalized by international law itself, completely independent of national criminalization. And then the third assumption is then that only acts that are universally criminal can be considered international crimes. Because international law applies to all states equally, an act that does in fact qualify as an international crime can be less than universally criminal only if in fact its criminalization depended on national criminalization. But again, the basic assumption of the direct criminalization thesis is that international criminalization neither depends on nor can be limited by the status of an act under international law. So those are the 3 assumptions. In short, the direct criminalization thesis assumes that an international crime is an act that is universally criminal regardless of its criminalization by states. And that raises a very fundamental question. How do we know which acts enjoy that status? How do we know which acts international law directly criminalizes? And there are 2 possible answers here. The first is avowedly naturalist. Well, we know an international crime when we see one because such crimes, quote, offend universal values or, quote, shock the conscience of humanity. Now, it's a very seductive formulation, but the problem is we don't know an international crime when we see one. Again, scholars have nominated a wide variety of acts as international crimes. So how do we determine which ones are genuinely international and which ones are merely pretending to be international? Naturalism can't answer that question because it is, again, basically by definition, completely untethered from state practice. So naturalism works only insofar as we all share exactly the same understanding of what offends universal values and what shocks the conscience of humanity, and practice indicates that that's simply not the case. There is no universal consensus. So that's one problem with the naturalist understanding of an international crime. It's also important to recognize that naturalism also fails to explain why certain kinds of particularly heinous acts, certain kinds of particularly grave acts, are directly criminalized by international law itself. A naturalist conception of an international crime is not in any way inconsistent with the idea that states have the fundamental obligation to criminalize and prosecute those acts. In fact, that was Grotius's position, as evidenced by his insistence, I keep losing my little clicker, in Book 2 of The Rights of War and Peace, that grave violations of natural law, the idea that international crimes are governed by the aut didere, aut judicare principle. So I'm not going to read the quote to you, but he had a naturalist conception of international crimes, and yet he understood an international crime to fundamentally be about what states have to prosecute and punish. So naturalism doesn't really answer in any convincing way what is an international crime and what is something other than an international crime. So the second answer would then be, at least ostensibly, a positivist answer. What's an international crime? Well, an international crime is an act that state practice and impenio juris establish as being directly criminalized by international law. That's pretty straightforward. It's also certainly possible. We could imagine state practice and impenio juris that establishes certain acts are directly criminalized by international law. But here's something surprising, or well, I hope you find surprising. There's actually remarkably little state practice and impenio juris supporting this idea of certain acts being directly criminalized by international law. And I'm going to run through 4 of perhaps the most promising sources of evidence for this direct criminalization thesis. First, we might think that direct criminalization thesis is supported by national legislation that incorporates international crimes into the domestic order, and then, of course, national prosecutions of international crimes pursuant to that national legislation. In fact, such legislation and prosecutions provide almost no support for the direct criminalization thesis. Why? Because they result from national obligations to criminalize, not from international law directly. In fact, that's the whole point of the indirect prosecution method that suppression conventions rely on. States incorporate and prosecute because they ratify treaties that obligate them to. That's a domestic obligation. It's not in any way a statement that international law directly criminalizes these acts. So those aren't very helpful. A second, and at least potentially more fruitful source, would be the ratification of multilateral treaties that affirm the direct criminalization of certain acts by international law. Fair enough. But again, those treaties are actually quite limited. There is no pre-Rome Statute treaty that criminalizes aggression. And in fact, the Assembly of States parties only adopted a definition of aggression a couple of years ago. There is no pre-Rome Statute treaty that criminalizes crimes against humanity. And although the very wordy Convention on the Non-Applicability of Statutes of Limitations describes crimes against humanity as, quote, crimes under international law, the convention has only been ratified by 54 states. Third, although the Genocide Convention does in fact affirm that genocide is a crime under international law, if we look at it from a historical perspective, its drafters viewed the convention as requiring national criminalization, not as creating direct responsibility under international law. You will look in vain at the drafting history of the Genocide Convention for a statement that international law itself criminalizes genocide. The term crime under international law in no way meant direct criminalization. It meant this was a fundamental act that all states had their obligation to criminalize domestically. Fourth, the Geneva Conventions, well, they're universally ratified, but they're suppression conventions. They don't affirm the direct criminalization of war crimes under international law. They don't even say that for the grave breaches. They put the obligation on states to domestically criminalize and prosecute war crimes. And then really, if we want to be picky, even relying on the Rome Statute for the direct criminalization thesis is at least kind of problematic, because its substantive provisions were not actually intended to create custom. And even if they were, the Rome Statute has been ratified by little more than about 60% of the world's states. So multilateral treaties that affirm direct criminalization don't really get us very far toward our core, so-called core international crimes. A third source, the International Law Commission's codification of the Nuremberg Principles. Everybody reads that in their first international criminal law class. The various International Law Commission draft codes of offenses against the peace and security of mankind. These sources do actually affirm the idea of direct criminalization, but neither the principles nor the code were ever adopted by the UN General Assembly, so they don't even count as state practice and impenio juris at all. They're simply the opinion of those people who were involved in their drafting. And then fourth and finally, again, in terms of potential sources for direct criminalization, would be UN General Assembly resolutions that affirm this idea of direct criminalization. And I imagine this is what most people immediately go to when they think about, okay, where do we get evidence for this idea of direct criminalization? But even if we assume that UNGA resolutions can create custom, and that is itself deeply disputed, the relevant provisions of these particular General Assembly resolutions are extremely weak candidates for the creation of custom. The most relevant UNGA resolution, the famous Resolution 95-1, it affirmed the principles of international law in the London Charter and in the IMT judgment. But again, we've lost the historical narrative. UNGA Resolution 95-1 did not declare the principles in the Nuremberg judgment to be customary. In fact, the UN General Assembly deliberately chose to avoid terms like reaffirms or confirms those principles precisely because states couldn't agree whether the judgment and the London Charter reflected customary international law. Gets us really almost nowhere. They very deliberately drafted it not to have any truly law-making effect. And you can go back to the original debates, and Bingbing Jia has written a fantastic article about how limited the value of 95-1 is. 96-1 affirmed that genocide is, quote, a crime under international law, but, like the Genocide Convention itself, simply emphasized the need for states to domestically criminalize genocide, didn't reaffirm the idea that somehow genocide was magically criminalized by international law itself, independent of domestic criminalization. So, lastly, UNGA Resolution 3314, again, another famous one, the definition of aggression. It only deemed wars of aggression to be crimes under international law. At the insistence of the British, the resolution provided that all other acts of aggression only gave rise to state responsibility. So even insofar as we look at the definition of aggression to establish direct criminalization, it would only work for wars of aggression and not any other kind of aggressive act. So there are major problems, I think at least, with trying to defend the direct criminalization of any of what we consider the core crimes of international criminal law, at least insofar as we're taking a kind of classically positivist approach to the creation of international law. Now, it's also important, I think, to recognize that this kind of magic words positivism, the idea that if you throw a crimes under international law into a multilateral treaty or a General Assembly resolution, then all of a sudden we have direct criminalization by international law itself, this idea is not only over-inclusive, but it's also under-inclusive in terms of what we might consider to be an international crime. This idea, this kind of magic words positivism, implies that at least some transnational crimes have an equal, if not perhaps even stronger claim to international status than some of the core crimes. Let me give you just one example, the oft-debated crime of terrorism. Everybody says, well, of course international terrorism isn't an international crime, and Antonio Cassese, the president of the Special Tribunal for Lebanon, just made it up in the judgment, and I agree with people like Ben Saul's kind of methodological critique of that. But if you look from a magic words positivism standpoint, in fact, terrorism has a pretty strong claim to international status. Here's the text of Security Council Resolution 1377, and I could have given you 10 more Security Council resolutions with exactly this language. The Security Council reaffirms unequivocal condemnation of all acts, methods, and practices of terrorism as criminal and unjustifiable, regardless of their motivation, in all their forms and manifestations, wherever and by whomever committed. That's pretty strong language. This was a unanimously adopted Security Council resolution, as are many others that have the same language. And this expression almost literally reproduces the IMT's definition of an international crime. So we have unanimous Security Council resolutions. We have the United Nations General Assembly, a number of resolutions using, again, exactly the same description of terrorism as criminal everywhere by anyone. Many adopted by consensus. We have UNGA Resolution 4960, UNGA Resolution 51210. Again, probably more than a dozen UNGA resolutions using this language. And then terrorism was also considered an international crime by the International Law Commission up until the very final 1996 draft code, when they eliminated it largely for the very tired old debates about the definition of terrorism. So if we're really going to take magic words positivism seriously, well, very hard to avoid the conclusion, I think, that terrorism is just as much of an international crime as the core crimes. Now, there's a very important and very seductive response to my positivist critique of direct criminalization. Hopefully it's in the back of some of your minds, namely that the creation of international tribunals with jurisdiction over the supposedly core crimes of international criminal law, that provides the state practice and the opinio juris necessary to establish this idea of direct criminalization. Very common definition of an international crime is an act that is prosecuted by an international tribunal. Now, there is much to be said for this response. It has the attraction, at least at first blush, of not, in fact, relying on national criminalization to somehow establish direct criminalization by international law. If international tribunals somehow automatically have jurisdiction to prosecute certain acts, in particular those acts that are directly criminalized by international law itself, well, then it doesn't matter whether those acts are criminalized domestically. And that would satisfy the direct criminalization thesis. But there's a fundamental problem with this argument. Argument cannot assume that any crime that is prosecuted by an international tribunal is automatically an international crime, because international tribunals prosecute all kinds of acts that nobody thinks are international crimes, and our old friend, the Special Tribunal for Lebanon, only prosecutes domestic crimes. So how can we distinguish between ordinary and international crimes that are prosecuted by international tribunals? How do we separate the two? The only possible solution, it seems to me, is to once again return to the idea of universal criminalization and distinguishing between two different kinds of acts. First category, acts that an international tribunal can prosecute only when committed by nationals of states that have consented to its jurisdiction. That would be the ICC. Put aside the Security Council for now. And in the second category, acts that an international tribunal can, at least in theory, prosecute no matter who commits them, even those that are committed by individuals who are nationals of a state that has not consented to the tribunal's jurisdiction. Now, acts in the former category clearly can't satisfy the direct criminalization thesis, at least in the absence of an international court that was based on a universally ratified treaty, because once again, the universal criminalization of those acts would still be limited by national law. And that's what the direct criminalization thesis says cannot actually happen. Acts in the latter category that an international tribunal can prosecute wherever, by whomever, that could satisfy the direct criminalization thesis, because they truly would be universally criminal, regardless of what states actually decided to criminalize. But that leads us to yet another question. How could an international tribunal have the truly global jurisdiction necessary to satisfy the direct criminalization thesis? Now, it's tempting to say, well, the Security Council. The Security Council could create a tribunal with the power to prosecute certain acts, no matter where in the world they're committed, no matter by whom they are committed. But that doesn't actually work, because not all individuals are subject to the United Nations Security Council's purview, and it's widely accepted that the Security Council can't, in fact, legislate for states that are not members of the UN. That's a much longer discussion than I did in my paper, but give me that for the sake of argument. So what's the solution? Well, there's an obvious one. The solution is universal jurisdiction. States can pool their jurisdiction in an international tribunal. We know that. That was the basis of the Nuremberg Tribunal, and it's the basis of the International Criminal Court. So if states do in fact have universal jurisdiction over a particular act, they can delegate that jurisdiction to an international tribunal. And an international tribunal that is based on universal jurisdiction would satisfy the direct criminalization thesis's universality requirement, because it would be able to prosecute international crimes committed anywhere by anyone in the world. So that would work. So then we have another question. What acts are subject to universal jurisdiction? Well, we could run through the unconvincing naturalist answer, but from a positivist perspective, it may be possible, in fact, to establish universal jurisdiction over certain kinds of acts. We could look at state practice and opinio juris and say, yes, there is in fact universal jurisdiction over these acts. And in fact, very few states and very few scholars question the very idea of universal jurisdiction at this point. So we have a potential solution. But here's an important point, I think. The direct criminalization thesis cannot be satisfied simply by showing that customary international law permits universal jurisdiction over a particular act. Instead, it needs to show that the existence of universal jurisdiction over a particular act does not depend on states being obligated to criminalize that act. Again, the basic assumption of the direct criminalization thesis is that an act would be criminal under international law, even if every state in the world considered that act to be completely legal. So if universal jurisdiction exists over an act only insofar as states are obligated to criminalize it, the direct criminalization thesis collapses into what I call the national criminalization thesis. The hallmark of an international crime would then be that all states are obligated to criminalize that act, thereby giving rise to universal jurisdiction, not that the act is criminal even in the absence of domestic criminalization. Now, unfortunately for the direct criminalization thesis, it is very difficult to see how universal jurisdiction could exist over an act unless states, and more precisely, unless all states, are obligated to criminalize it. And let's look at both the prosecuting state and the territorial state. Start with the prosecuting state. Because the direct criminalization thesis cannot depend on domestic obligations to criminalize, it must assume that a state has no obligation whatsoever to criminalize an act committed on its own territory, yet has the right to prosecute that act when committed on the territory of another state. But how can that be? How could a state have the right to prosecute an international crime only when it was committed abroad? Such selectivity seems practically, theoretically, normatively, whatever, indefensible. And in fact, that is no doubt why every treaty that permits universal jurisdiction also contains a national criminalization requirement. The Genocide Convention, the Convention Against Torture, the Apartheid Convention, yes, they acknowledge universal jurisdiction, but they also obligate states that ratify those treaties to domestically criminalize those acts. That's the prosecuting state. It seems even clearer that a state's right to exercise universal jurisdiction over an act depends on the territorial state being obligated to criminalize that act. Universal jurisdiction is not simply about giving states the right to prosecute acts that infringe upon fundamental values of the international community. It's about giving states the right to prosecute acts that infringe upon fundamental values when the territorial state cannot or will not do so itself. Precisely what justifies universal jurisdiction is the territorial state's failure to live up to its international obligations. If a state is living up to its international obligations, if it is criminalizing and prosecuting international crimes, it would be very difficult to argue that other states would still be entitled to exercise universal jurisdiction over acts committed on that state's territory. And this is by no means a radical explanation of universal jurisdiction. I did not come up with this one. On the contrary, every philosophic defense of universal jurisdiction, Winchat Lee's, Alejandro Chetman's, Anthony Duff's, all of them condition universal jurisdiction on a state's failure to fulfill its international obligation to prosecute certain kinds of acts. International jurisprudence also supports this explanation. We can cite a couple of my favorites, the NMTs, the hostage judgment, the Einsatzgruppen judgment. Both of them justify universal jurisdiction on the territorial state's failure to act itself. That was the explicit holding of the Spanish High Court in the Guatemalan general's case. Same explanation that Judge Higgins and others gave in the arrest warrant case. And then finally, it's not an accident that many states condition their own universal jurisdiction legislation on the failure of the territorial states to criminalize a particular kind of act. Germany, Austria, Serbia, Somalia, Chile, they all recognize that what justifies universal jurisdiction is the territorial state's failure to live up to its international obligation to criminalize and prosecute particular acts. So state practice in opinio juris, in short, cannot establish universal jurisdiction without relying on a pre-existing national obligation to criminalize. If that's the case, it is impossible to defend the direct criminalization thesis on positivist grounds, because its definition of an international crime only works insofar as universal jurisdiction exists over that particular act. So if you have to have domestic criminalization to have universal jurisdiction, and you have to have universal jurisdiction to justify the idea of an international crime, the direct criminalization thesis, which again says it doesn't matter what states do, simply doesn't work. So, I think we have to reject, again, on positivist grounds, the idea of direct criminalization. Now, that doesn't mean that we have to abandon a positivist understanding of an international crime. It simply means that we have to accept a very different definition of an international crime. Namely, an international crime is an act that every state in the world is obligated to criminalize. It is precisely the existence of a universal obligation to criminalize that justifies universal jurisdiction over certain acts, and it is precisely the existence of universal jurisdiction over certain acts that permits the international community to create an international tribunal that can prosecute certain acts no matter where and by whom in the world they are committed. So that's the idea of an international crime that I would defend. Now, that idea, what I call the national criminalization thesis, it of course presupposes that international law can in fact obligate all states everywhere to criminalize a particular act. The question is then, well, where does that obligation come from a positivist perspective? Well, there are two possibilities here. A universally ratified treaty that imposed an obligation to domestically criminalize, that would be universal, or customary international law. Now, the universally ratified treaty mechanism is very straightforward. Obviously, it can't be a non-universally ratified treaty, because treaties only bind state parties. And if a treaty is not universally ratified, well, then once again, the universal criminalization of an act would still depend on domestic law. So you have to have you have to have a universally ratified treaty to establish the national criminalization thesis. Custom, this would work better. Custom, of course, better establishes a universal obligation to criminalize because custom binds all states equally. And that's critical because positivism actually supports the existence of a customary obligation to domestically criminalize certain acts far more strongly than it supports the idea that certain acts are directly criminalized by international law itself. In particular, if I can find the little stick again, the national criminalization thesis can rely on 4 or maybe 5 important sources of international law that the direct criminalization thesis simply cannot. First, it can rely on non-universally ratified treaties that establish the obligation to criminalize, such as the Genocide Convention. Anything that establishes a domestic obligation to criminalize is some state practice in opinio juris in favor of this idea. And frankly, that includes the Rome Statute. Because if you recall, the preamble to the Rome Statute actually does affirm the obligation of states to prosecute international crimes domestically. The national criminalization thesis can rely on national legislation that results from the ratification of treaties. It can rely on national criminal prosecutions pursuant to national legislation, because again, these obligations come from the ratification of treaties that impose a domestic obligation to criminalize. The national criminalization thesis can rely on UNGA resolutions that obligate states to criminalize certain acts. So the Genocide Resolution, which says crimes under international law, but is really just a suppression convention, it does provide state practice in opinio juris in favor of a universal domestic obligation to criminalize certain acts. And then, again, at least arguably, all the state practice based on universal jurisdiction can support this because, as we've seen, universal jurisdiction itself requires a domestic obligation to criminalize. So that's the idea of an international crime that I would defend. And then finally, to bring this to a close, we come to probably what is most people's fundamental question. Well, if we reject the direct criminalization thesis in favor of my national criminalization thesis, well, what acts actually qualify as international crimes? What does it do to our traditional understanding of what international crimes are? Well, from a strictly positivist perspective, and again, I have no problem with the idea of just openly accepting a naturalist understanding of international criminal law. If we accept naturalism, we can have our traditional categories. But if we're going to take positivism seriously, and the judges all the way back to Nuremberg, when nobody really could have claimed to have been a positivist, were still insisting that they were strict positivists. From a strictly positivist perspective, the prototypic international crime is clearly a grave breach of the Geneva Conventions. The Geneva Conventions are, in fact, a universally ratified set of treaties, so all states in the world are, in fact, obligated to criminalize the grave breaches. I think there's no question that they qualify as an international crime. Beyond the grave breaches, well, the positivist status of the core crimes is still a little murky. The strongest argument would clearly be for genocide. The Genocide Convention has been ratified by 142 states. As I said, the UNGA Resolution 96-1 was in fact adopted unanimously and imposes an obligation on states to criminalize. And in fact, 116 states have incorporated genocide into their domestic penal codes, and 92 of them actually provide for universal jurisdiction over genocide. So there's strong evidence, if not conclusive, of a customary obligation on states to domestically criminalize genocide. Now, establishing a customary obligation to criminalize crimes against humanity, well, there we probably have to rely on the Rome Statute. It's at least been ratified by 124 states. 90 states have incorporated crimes against humanity into their domestic penal codes, and 78 provide for universal jurisdiction over crimes against humanity. But in fact, only 54 states have ratified the only treaty that actually concerns crimes against humanity, this Convention on the Non-Applicability of Statutes of Limitations. And then finally, with aggression, well, this is probably the most difficult case of all, at least outside of war, which was at least deemed an international crime by the UN General Assembly's Resolution 3314. No treaty requires national criminalization of aggression. Again, at least not pre-Rome Statute, and not yet the Rome Statute. And very few states have ever domestically criminalized aggression. So that's the status of the core crimes. Let me just simply wrap this discussion up by pointing out the positivist limitations of the direct criminalization thesis mean that I think anyway, that we have to reject this hard distinction between international crimes and transnational crimes. Because, from a positivist perspective, an international crime is simply an act that all states everywhere are universally obligated to criminalize. The distinction between an international crime and a transnational crime is quantitative. It is not qualitative. A transnational crime is simply a crime that has not yet risen to the level of a customary obligation to criminalize. And that, I think, is really critical, because it means that, again, from a positivist perspective, many transnational crimes actually have at least as strong of a claim to international status as the so-called core international crimes. Let me give you some statistics. At least 6 suppression conventions have been ratified by more than 95% of the world's states. So if any kind of treaty can give rise to a customary obligation, it would seem to be these. We have the Non-Proliferation Treaty, the Chemical Weapons Convention, the Safety of Civilian Aviation Convention, and the Illicit Traffic in Narcotics Convention, the In-Flight Aviation Convention, the Hijacking Convention. All of these have been ratified by more than 95% of the world's states. Seems to be as close to a customary obligation to criminalize as one could imagine. Then you have another big set that have been ratified by more than 90% of the world's states, and I won't read them to you, you can see them up there, all the way down through the Internationally Protected Persons Convention, and then 4 others have been much more widely ratified than any of the so-called core crime conventions. And there you have the Hostages Convention to the Convention Against Torture. So, the bottom line, I think, is this. Really the most fundamental assumption of international criminal law, this idea that certain acts are directly criminalized by international law itself, can really only be sustained by relying on at least what I would consider to be a problematic naturalism. From a positivist perspective, if we want to found international criminal law on a positivist conception of the creation of international law, we have to accept 2 things. First, that international crimes are acts that states are universally obligated by international law to criminalize, and second, that the act of genuinely international crimes looks very different than the list that we are traditionally used to. Thank you. So, as I said, everyone hates my argument, so please, let's have a discussion about it.
Well, thanks very much, Kevin, for that very not boring presentation.
Speaking
So
for yourself.
I wasn't bored. I didn't sleep. Not 1 minute.
That's because I'm loud.
Yeah, that's true. Okay, you got me there. If we can open up the floor to questions, I hope...
Don't call him down.
I won't call him down, just kidding, I will. But we need to... Alright, there she is. Like magic. Please speak into the microphone and announce your name as well as your question. Thanks.
Hello. So I'm Dov Jacobs. I'm Gorsha Center, co-organizer of this great talk. As you said, your talk is very dense, and I won't bore you with all my minor, comments I'll have. I'm sure I'll see your draft at some point. Two things. One challenge to your methodology, but again, as you spoke very fast, and is I think at some level I agree with your rejection of the naturalist argument, obviously, but I'm wondering if you're not conflating a bit the nature of an act and the enforcement of it. When you keep referring to the international criminalization and saying it can't be international criminalization because, look, states are asked to enforce it. I can see the logic there, but if you take a view of, like a role-splitting view of Georges Sell, then domestic courts are acting in the name of the international community, and then someone can fall back on their feet using that, because they're not acting as domestic courts. So that's something to think about. More fundamentally, my question at the end is not what crimes are international, is why do we need that notion at all? I don't know what an international crime is. Why do we need a concept of an international crime? For me, asking the question as saying, what is God? It's a biased question because you're assuming it exists. So it reinforces the idea that crimes are kind of in an ether. It's what allows ICTY to say, well, we don't care we were created after the fact because the crime was there in customary law somewhere. It was criminalized somewhere out there. And I think that's the problem with, your last point doesn't answer that problem, because you still have international courts who are claiming something. And ultimately, I think crimes don't exist in the void. They exist in an institutional setup. It's all about jurisdiction. What community has a criminal law setup with the courts to prosecute certain acts that are odious for that society? And there you always have an institutional setup. And then you don't need the international crime. Whatever court there is has jurisdiction over a particular crime. It's jurisdiction. So the ICC doesn't have jurisdiction over core crimes. It has jurisdiction over the 4 crimes it defines. And that's the end. I don't see the added value of having the concept in the first place, to sum up.
Okay. Excellent questions. Let me start with the first one. Again, kind of good, old-fashioned positivist that I am, I would have no problem with defending the direct criminalization thesis if we had evidence that states are criminalizing and prosecuting crimes truly in the name of the international community because they have this view that international law directly criminalizes things and they have an obligation to help it carry it out. But that doesn't seem to be what they're doing. What they seem to be doing is we're incorporating genocide because we've signed up to a treaty that requires us to do so. We've criminalized the grave breaches because we ratified the Geneva Conventions. They seem to be acting in a very classic way in response to treaty obligations and not into a kind of a broad, sweeping, international law says we need to do these things. And Dapò Conde made a point very similar to yours. And I went back and I looked. Could I find evidence that some states are prosecuting international crimes because they think they have to do so in the name of humanity? And I can't find it. It's probably out there somewhere. But again, all I'm trying to say is we need to take positivism more seriously than we do. And then we bandy about this idea, it says crime under international law, so it's an international crime, without really thinking about what does it mean when the drafters of the Genocide Convention use that expression. And you go back and you look at the drafting history and it says, well, it was just a shorthand for acts that are really bad that all states have to criminalize. So in some ways I'm just trying to kind of historicize these expressions that we use today and say if we take positivism seriously, it's just hard to justify what the Nuremberg Tribunal said in 1945 and the International Law Commission said a couple of years later. So that's the first point. The second point is a really important one, and I'll do the wonderful elision or the way the I'll slough off your question by saying, well, I deal with that extensively in the paper. But I will say this. The reason I think that it's important we get the idea of an international crime right is precisely to promote an idea of kind of modesty toward international criminal law that I think you and I, in particular, share. That there is this idea that international crimes are somehow just magic. They wipe away the active state doctrine. They wipe away statute of limitations. They wipe away immunities, functional and personal. They impose auditare ad judicare obligations. They bring about universal jurisdiction. I mean, I actually catalog all of the things that supposedly follow from something being an international crime. And so part of my argument is, well, insofar as we believe those things actually do follow from an international crime, I can explain them better by looking at universal domestic criminalization than direct criminalization. But more deeply than that, I'm very skeptical that a lot of those things follow from international crime. And that, to me, is also a product of kind of the naturalism that underlies so much of the field. That if we dissolve this idea that there's something fundamentally different about an international crime and a transnational crime, that maybe we will not be quite so certain that international crimes have all of these magic properties. I mean, I don't think most people would say that narcotics trafficking eliminates the active state doctrine and attracts universal jurisdiction. There's that sense that those are lesser crimes, and I'm just not sure that is really the case. So that's kind of where I come out on why it matters what the notion of international crime is. You don't have to buy my answer, but that's the answer.
Hi, Kevin. Manuel Ventura. I wanted to touch on crimes against humanity. I think you touched upon, and I think your basis for your thesis on that specific crime was the Rome Statute. And you said that the preamble that recognizes that states have the obligation to exercise their jurisdiction with respect to international crimes. But I'm curious, because nothing in the Rome Statute actually explicitly states that any of the crimes have to be domesticated into international law. So contrary to, for example, the genocide, that's the direct opposite of the Genocide Convention. So I'm wondering how it is that you justify crimes against humanity on a treaty that doesn't explicitly provide for the domestication of that offense.
Oh, I don't want to. I'm not sure that you can. I'm skeptical that even the Rome Statute does it.
So then, what has the ICTY been doing for the last 20 years? I mean, if crimes against humanity, I mean, if that's your thesis, then I'm wondering.
Oh no, but there's absolutely nothing wrong with the Security Council creating an international tribunal to prosecute certain acts over states that are subject to its jurisdiction. I have no problem with that. It's the idea that we can, again, somehow magically get from these very kind of ad hoc prosecutions of crimes against humanity directed in a series of tribunals that only dealt with kind of one set of crimes by one side, or two or three sides in the case of the ICTY, that again, that somehow we can get from there to this is an act directly criminalized by international law itself. That's the leap that I find very problematic. In my paper, I say, with my national criminalization thesis, that maybe not even that can really be defended positivistically. This article is basically an introduction to the book that I'm working on, which is really kind of a methodological history of international criminal law. And really what I want to come out and say is, on the one hand, judges have always claimed to be good positivists. On the other hand, we know full well that they're not good positivists, because we all read ICTY decisions. But third, could we have actually imagined a strictly positivist international criminal law? And I think the answer is probably no. I think there are structural differences between international criminal law, particularly as a form of criminal law subject to the principle of legality, that means that if we were going to be pure positivists, we would not have a field. And so part of it is a claim to say, okay, let's just acknowledge that this is a deeply, deeply naturalist area of international law. That it's been made up by judges in response to very deeply felt, very passionately advocated ideas of what was truly offensive to the international community. And that even if we can't tick all the boxes with state practice and opinion juris, that we simply accept that and we deal with the consequences of it. So I'm deeply skeptical of positivism across the board. Really what I was trying to do tonight is just simply say, if we want to take positivism as seriously as we can, this idea that an international crime is an act that all states are obligated to criminalize actually has a lot more support than this idea that certain things are directly criminalized by international law itself, independent of what states are doing. So your point is extremely well taken.
And one more question, follow-up. If indeed there is this obligation that you say, to domesticate this offences, so then I'm curious, why is it that states don't protest other states not going ahead and doing that? Because there's many countries that haven't domesticated many what we call core international crimes, reducing more and more. But I'm wondering why it is that states don't, protest. Why aren't you domesticating this? Like any other, presumably, international legal obligation.
Well, in some ways, I would turn that around and say that you're precisely making my point. That if domestic incorporation of international crimes was somehow a reflection of states' beliefs that international law itself demands this of us, they probably would protest. But in my view, the reason they don't protest is because both states, unlike most international criminal law scholars and international criminal law judges, really exist in the realm of treaties. You ratify a treaty, you carry out its obligations, and states do protest when a state ratifies the Geneva Conventions and then doesn't incorporate the great breaches into their national legislation. That's a very concrete wrong. This abstract wrong that you're somehow letting international law down by not incorporating international crimes, I don't think states think that way. I don't think states really think about this idea of direct criminalization itself. They operate in the realm of treaties. So that's why I think you don't see more protest about this. Much more quotidian considerations.
Otto Spijkers of Utrecht University. I was wondering how your argument is linked to, or maybe not, human rights obligations. Because you could argue that certain obligations under human rights law oblige states to criminalize certain acts. Like if you need to protect the human right to life for everyone within your jurisdiction, then the obvious way would be to criminalize murder, to say something obvious. So, but in your story, you're arguing that there's only an obligation to criminalize international crimes, right? But murder is not an international crime. So then states would be at liberty to either criminalize murder or not. But then any state that has signed up to human rights obligations can't make that choice. It's basically obligated to criminalize murder. But still, it's not an international crime.
I want to say that your point also supports the national criminalization thesis better than the direct criminalization thesis, because we're still talking about states being the ones that are fundamentally obligated to criminalize certain kinds of acts. Now, it does seem strange to say, oh, well, murder is an international crime because all states are obligated to criminalize it. But I'm not a human rights lawyer, so I'm not exactly sure how those obligations function. I don't know. Everything that you just said makes complete sense. I've never heard it formulated in quite that way, that human rights law would obligate states to criminalize murder because otherwise they couldn't fulfill their obligations. I mean, all states have prohibitions against murder in some form. So I think
how else would you guarantee the right to life?
I completely agree, but I suppose that I imagine the acceptance of the right to life as a universal human right is based on the fact that all states do criminalize murder to some extent, and did so long before the Universal Declaration of Human Rights and the ICCPR. So I would think that those documents are built out of what states have already considered to be the fundamental human rights values, instead of kind of the other way around. But I can't give you a convincing answer because I have to think about it more. But nothing in what you said would indicate that there's direct criminalization of certain acts by international law. And that's really kind of my basic point.
Can I jump in on that?
Sure.
From the human rights perspective, the human rights obligations that a state has under the international treaties or the international framework, that's the obligation that a state would have to its citizens or those within its jurisdiction. So it's not the criminalization of murder is different from the obligation to ensure the right to life. Those are two separate. Because there is no state responsibility if someone commits a murder. within your jurisdiction, the state is not then responsible for not preventing that murder. So the set of obligations is different at the human rights level versus the domestic criminalization of things like murder, I would say.
Yeah, I like that. I mean, really,
It's true.
I mean, again, the details I think are less important than the general point that I'm trying to make. That the dominant narrative of international criminal law over the past 70 years, since the deeply naturalist moment of Nuremberg, has been kind of the aggrandizement of international law. That it stands above and is more powerful than states. When states are still, like it or not, and this could be, the apologist aspect of international law, or my argument, that international law is still fundamentally built by states. They're still the authors of it. They're still the subjects and objects of it. And we just kind of, because of the utopian impulses of international criminal lawyers, we just want international law to do all of these things that it just doesn't do if you take positivism seriously. And again, I'm not saying that because if you take positivism seriously, international law is not quite as magic as it once seemed, that you can't have the magic of international law. It's about, let's just acknowledge the fundamentally naturalist aspect of this. And let's acknowledge that what we're trying to do is limit states in ways that states themselves are not willing to actually be limited, and take some of their sovereignty away from them. And let's just be open about that. And that's what I have. That's my problem with the narrative of international criminal law, that we're pretending to be positivist, yet we have generated an international system with the notion of international crimes and all of the magic consequences of international crimes that just don't reflect what states actually do and what they actually believe. And again, there's nothing wrong with not being a positivist. My problem is those who claim to be positivists yet have an extraordinarily desiccated understanding of what positivism actually is. So in that sense, nothing follows at all from my argument other than a plea to clarify what our fundamental starting point is for how we see international law actually created.
Hi, thanks for your talk, Kevin. Rogier Bartels. One quick follow-up on what Jessica said, but what about extraterritorial application of human rights, where a state responsibility does arise for preventing murder taking place by a state agent or torture, etc.?
Sure, by a state agent, that's not problematic, but with respect to murder in a domestic situation, when it's not a state agent, then you're outside of the international human rights framework.
But yeah, that's why I brought in the extraterritorial. But Kevin, you're of course correct that if you would apply a very strict positivist approach and a very strict principle of legality, that we would have, at least before the ICC, where you can have it would be possible to have a strictly positivist approach and a principle of legality, at least for so far it's all state parties, not for non-state parties. But we wouldn't have any ICL. I mean, Nuremberg, etc. ICTY wouldn't be there. But bearing that in mind, and it's more of an observation that you could maybe comment on, the Tadic conditions which were developed to deal with other serious violations of laws and customs of war, Article 3 ICTY statute, have as their fourth condition that it needs to be direct criminalization. But it's basically the Tadic conditions are the direct criminalizations theory. But then the fourth condition, what the tribunal has looked at in order to show that the fourth condition was fulfilled, are basically exactly the five areas that you find for as proof where you can find the national criminalization thesis: national legislation, national prosecutions, UN Security Council, UN General Assembly resolutions, state practice, and the fact that there are conventions that criminalize something. So, yeah, that's just that where the ICTY calls it direct criminalization, it relies on what you refer to as evidence of national criminalization.
Yeah, no, it's a very, I hadn't thought about it, but it's a very useful comment, because again, I suppose this is kind of my implicit point, that it's a very strange notion, this idea of direct criminalization by international law. If you go back to what the ILC said a long time ago, based on the IMT judgment, the idea that it really doesn't matter what states do because international law is criminalizing itself. Well, this is what started this article to begin with. I was like, how the hell do you actually get this idea unless you are just a naturalist and you say that there are certain things that are criminalized by international law? What do you look at if you're a positivist and you want to come up with this notion? And what I realized was, well, what you're looking at is actually a very different understanding of an international crime. You're looking at what do states think that they themselves have to criminalize themselves that then they can kind of transpose to the international level. So really what I'm trying to say is, why in 2015 are we still trying to justify what is really an avowedly naturalist understanding of international law developed in 1946 when it was unavoidable to be naturalist, no matter what you actually called yourself? And so how much actually follows from my argument, I don't really know, but I think the narrative changes fundamentally, that we say international criminal law as a naturalist enterprise was born in 1946, and as a positivist enterprise it was born in 1998 or 2002 with the Rome Statute. And I think one of the great things about the Rome Statute is precisely that we are moving toward a more strictly positivist understanding of international criminal law. And I got lots of problems with the judges, I got lots of problems with various provisions of the Rome Statute, but that motivation to actually adopt a treaty that every state in the world could ratify, that defines the crimes and the modes of participation and the defenses and has elements, I think that's incredibly important, because the problem with naturalism, outside of kind of theoretical concerns, is it's very difficult to generate the kind of specificity that the principle of legality requires. And the principle of legality is a fundamental general principle of criminal law, in my opinion.
Yeah, I totally agree.
Yeah.
On that particular point and on that sentence in bold, there was of course a certain overlap between the persons who drafted this and the persons who...
Sorry, there was a certain...
overlap between those who drafted this particular phrase and those who were engaged in the negotiations of the Rome Statute and drafted the Rome Statute. And that particular phrase is the direct answer that always was given, of course. What do we do with states that do sign up to the treaty or ratify the treaty, but then afterwards they don't implement it in the national legislation? And the answer is always, doesn't matter, it's a crime, because whether or not it's incorporated in national law. So I'm not sure if that could possibly explain why that sentence is in the draft code. But
I'll think about it. Yeah.
Anybody else? Dying to ask a question? Here's your chance. Going.
I have more questions if you want to prolong the evening.
We can fly.
You and I can chat about it afterwards.
Yeah. We do actually, I see another familiar hand.
Can't resist one follow-up.
One more. No. I saw your list at the end and all the number of ratifications. Yeah, there we go. So, just if I understood you right, are all those treaties, like the provisions relating to criminalization in all those treaties international crimes?
These are all suppression conventions.
Okay. So
all imposing domestic obligations to criminalize. And all I'm really saying here is that, if we're going to accept that certain widely ratified multilateral treaties can actually pass into custom, and that's, again, a deeply contested idea, but if we do accept that that is the case, you've got a very strong argument for these being truly universal obligations to criminalize because of the overwhelming number of ratifications that they have. And so in my kind of analytic view of what international crime is, these are the kinds of treaties that can generate the universal obligation to criminalize that justifies the idea of an international crime, as I see it. That's all I'm trying to say.
So then, in your view, these are presumably international crimes, each one of the treaties?
Well, I mean, it depends on how we view the passing into custom of multilateral treaty obligations.
Right.
But again, if we accept that, how can you say that treaties that are ratified by 95% of the world's states are not universal obligations to criminalize?
Because few people describe them in that way. I mean, we don't have international tribunals for a lot of these things. I mean,
right, but why not?
So, because we don't. I don't know, because you'd be on a minority on that, frankly, if you go through each one of these and saying each one of these are international crimes on the same level as genocide, crimes against humanity, and war crimes. So
that's again what I'm saying. So it's easy to make that claim, but then from a positivist perspective, okay, well, where's your evidence that the war crimes, crimes against humanity, and genocide are stronger positivistically than these? Obviously, you can disagree with my analysis of them, but that's the point that I'm trying to react against. Like, of course, genocide is an international crime, because that's our narrative. That was Nuremberg. It was the Nazi genocide that gave rise to the Genocide Convention. And again, I have no problem with that, but then you look at the history of the Genocide Convention, it is essentially a suppression convention. It is not a convention designed to create international criminalization in the way that it was imagined at Nuremberg. That's my response. And I think universal jurisdiction is really the crux of my paper, because most people say there's universal jurisdiction over an act because it is an international crime. And if something's an international crime, states can exercise universal jurisdiction. And I'm arguing positivistically that's precisely backwards. What allows us to describe something as an international crime is universal jurisdiction over it, because it's the possibility of universal jurisdiction that would allow states to come together and prosecute, say, genocide anywhere in the world, even if states don't consent to that tribunal. That's the key, to me, of an international crime, that it's universal jurisdiction over it. And universal jurisdiction, to me, comes from domestic obligations to criminalize, not from this kind of magic status of international crime itself. So I'm trying to reverse that equation.
Last minute.
Oh, let the poor people go, Jessica.
I will let you all go, but first, I would like to say thank you once again to Kevin. Great presentation. And I would thank you for your excellent questions and your answers. Thanks for showing up tonight. I don't know if the weather's not really great. It's been off and on all day, so it's kind of hard sometimes to get out here. Thanks for coming. 2 announcements for Supranational Criminal Law Lecture Series events coming up. On the 17th of March, we're going to have a lecture on Palestine and the International Criminal Court. And the speakers are Raji Surani, who's the director of the Palestinian Center for Human Rights, and Shawan Jabarin, the director of Al-Haq. And then on 29th of April, the outgoing judge Ekaterina Trendafilova will reflect on her 8 years on the bench at the International Criminal Court. And we will also have the ICC Deputy Prosecutor James Stewart. So put those dates in your calendar. The date for James Stewart's SCL lecture is still being discussed, but just to get it on the agenda. And then, of course, others will follow, so please keep your eyes on our new website. And even better, you can sign up for our mailing list or follow us on Facebook or other social media outlets. And I wanted to one final note is to let you know that increasingly videos of these lectures are appearing online on our fantastic international crimes database. And maybe, Dove, you don't even think we need such a database, since maybe international crimes don't matter. But until that's the consensus, we will still run the database. That you can find at internationalcrimesdatabase.org. And Kevin's talk this evening will be appearing there shortly. So have a look. Thanks again for coming, and we'll see you the next time. Good night.